The next case is Vermilion Shores Athletic Club Owners Association versus Shoreline Village Apartments, LLC. Each part will have 15 minutes to send their argument. Tell how long that's reserved for rebuttal.
Oh, sorry, 3 minutes, please.
3 minutes. I'll be keeping track of the time up here.
Okay.
When you get to about a minute left, I'll give you a notation. You're down to about a minute left, so you're aware of that.
Thank you.
And I'll do the same for you at Pelly when you're running low at the end of your time.
Thank you.
I probably won't for rebuttal because we don't have a whole lot of time. I may not make that same warning during rebuttal time.
Okay.
The arguments are being recorded, so when you come up to the podium, first please introduce yourself for the record. And if you can, stay behind the podium so we can hear you, and also being visually recorded so if we can keep you on the recording. You should not use the term, the name of any child, minor, victim. I don't know if we have that in this particular case. If you were for some reason worried about that, don't use the name of a child, minor, or victim. Indicate by initials or a designation by child or victim. We are ready to brief and are ready to proceed whenever you are.
Good morning. Thank you. May it please the court. My name is Steve Ott. I represent the appellant, the Shoreline Village Apartments, and we reserved the 3 minutes already. This case is about an entity, one property, trying to enforce restrictive covenants, which are the CCRs, on another property without having being in the chain of title and without there being a public records exception to the notice. It's like, this case is just exactly like me putting a restrictive covenant on my neighbor and saying, there's a restriction saying you can't rent your house. And then that's the same kind of restrictions, same kind of actions that's going on here. The beginning of this started back in 2002. There's a lot of Vermilion names here. So the Vermilion Shores Development Group transferred this property to the Vermilion Shores Apartments, LLC. That's not us. In 2003, CCRs were recorded in 2003, and the bylaws that were attached to the CCRs listed legal descriptions. Now this is a big property, and it's bisected east to west with the railroad tracks. And there's a northern track, and there's a southern track, and our dispute is on the southern track. It has nothing to do with the northern track. But the CCRs that were recorded that are in dispute included legal description was only the north track. It didn't have a description in there for the southern track at all. It also references condominium development in the CCRs. Our association, the Shoreline Village Apartments, is not a condominium. Neither is the appellee in this matter. So then, that was in 2003, that was created, CCRs were created. In 2015, Vermilion Shores Apartments split that southern parcel into 3 parcels. And so they're identified as parcel number 28, 29, and 30. Those are the last 3 digits on the permanent parcel numbers. So the long expression of numbers, I'm just not going to repeat them here. But in this deed from Vermilion Shores to the 3 parcels, there was no reference of CCRs. And then the next deed that was recorded, so these were recorded almost simultaneously. Vermilion Shores Apartments conveyed 28 to the athletic club. And they deeded, so this was done. This deed also conveyed the CCRs. That deed in 2015 conveyed the CCRs to the athletic club. So now that parcel is encumbered with the CCRs. In 2016, a year later, almost a year, Vermilion Shores conveyed lot 30, to us, to Shoreline Village Apartments. This is the largest of those 3 parcels, about 15 acres. And again, in that deed, there's no reference to the CCRs. And that's in stark contrast to the deed to the athletic club, where they were included, specifically included.
Just for clarification, there's no dispute here that these CCRs are not in the chain of title. Is that true?
From us, right,
So their argument is it is,
yes.
because it says it in a general sense?
I'm sorry?
Because there's a general
Well, then
wording? I mean,
yeah.
I guess, I don't.
What's their argument?
Right,
They argue two things. One is, what they argue that it is in the chain of title, and we can show that it's not.
right.
And then they argue, well, look at, the same guy developed all this and signed the deeds. So he knew about the CCRs, so he accidentally left them out, and he should have, and he had knowledge, he certainly had actual knowledge of the CCRs.
So that sounds to me like that both parties don't dispute that language-wise, it's not in the chain of title.
You'd have to ask the applicant. But I think you're right, and I think that if they aren't, they should. And so, going on further, Shoreline Village Apartments divided its one lot into two. And then on the one spot, on the 30, so the two spots were 33 and 34. And on 34, they got a mortgage. And the title insurance for the mortgage in lot number 34, which is in that southern section, doesn't have a preference or exception in Schedule B to CCRs. And then the preliminary judicial report for the foreclosure sale is a title report, and the CCRs are not included in that. So there's again, clearly there's no reference to this issue in the chain of title. What they do argue is constructive knowledge and constructive. We had constructive knowledge, so they're binding on us. And they say, well, that's because they're public records, and therefore we should know about them. And again, there's two statutes that are involved with public records and official record. First one is 1301.401 in the Ohio Revised Code, and that defines what a public record is, and it defines two types of public records. One is an official record under Revised Code 31708, and one is pursuant to 1309, which is a secured transaction under the UCC, so we're not involved with that at all. So if you look at 31708, there's 29 documents listed that are official records. The CCRs don't fit any one of those at all. There is a reference to a condominium association document, but we're not condominium associations. And neither is the appellee. They're not condominiums. So we're not an official record, so it doesn't apply. They can't have a constructive knowledge of the language. And we have also supplied case law that is supportive about these kind of constructive knowledge things, Supreme Court case, and it's just that the constructive notice doesn't work if it's outside the chain of title in these kinds of cases. Lot ownership can be a condition. There's another case they're talking about the bylaws and where the bylaw is applicable to this association. But they said the lot ownership can be a condition of membership, of course. That is, the restrictive covenants apply, but membership cannot be mandated without restrictive covenant. And so we don't have, in this case, chain of title, we don't have constructive knowledge. There's no way that those CCRs are applicable to Shoreline Village Apartments. And so we feel there's no genuine issue of fact that the Shoreline Village Apartments are encumbered. And we're entitled to judgment as a matter of law based upon the facts or the law as we presented. As a result, we believe the trial court erred in its interpretation and application of the law, the common law, the Marketable Title Act. And for the reasons cited above, we believe that Shoreline respectfully request that this court reverse the decision of the trial court, award summary judgment to the Shoreline Village Apartments, and deny Vermilion Shores Athletic Club's motion for summary judgment. Thank you. Thank you for your time this morning.
Thank you. You'll have the remaining time for a moment.
Thank you.
May it please the court, and good morning. My name is Cullen Cottle, here on behalf of the APLE, Vermilion Shores Athletic Club Owners Association. I think it's important in this case to realize that it's really about preserving and maintaining the integrity of a mixed residential use community. It has to be funded in some way. We have a combination of homeowners associations, condominiums, as well as apartments. And I think if you look at the overall development plan, which was all under the umbrella of figures and entities that are related, you will see that the apartment complex in this case, the appellant in this case, is subject to the declaration of the association.
But I think the issue is this the right cause of action if it's not in the chain of title? Because you could do unjust enrichment, you could have made a claim for breach of implied contract, but we're here when you're talking about this being a property interest in a foreclosure.
Yes, a property interest in a foreclosure.
So is it that? If there's nothing in the chain of title that references this particular condition or restriction?
I think it's important to realize that the entities that created the ultimate parties that are on appeal in this case are all related. That the initial development organizations, and in particular the principals of those organizations, were intimately involved in terms of how this all played out. We have deeds that have gone from entity to entity, and by virtue of omitting, whether by omission deliberately or unintentionally, the reference to the CCRs, it doesn't necessarily make them inapplicable. We have conduct of the parties that I think is very important to reference here.
I want to get back to that too. We're talking about summary judgment being granted here. Wouldn't there be an issue of material fact here if that was really the law that that it's the conduct of the parties that would infer whether there was notice, or it seems as though the judge in the order makes that kind of ruling without, as if it's a bench trial rather than a summary judgment.
Well, I think that what the court determined was that there was no issue of material fact that remained to be litigated. And in this case, I think that if you look at the conduct of the parties, what you will see is that that factual illustration plays out. That what you have are individuals who are tenants within an apartment complex that know they have the use of these facilities. We have a corporate entity that governs that particular apartment complex.
So that conduct would, as a matter of law, infer they knew all the details of the condition?
I think that there are 2 points. One is that this document was recorded. So they are on recorded constructive notice that these documents in fact exist. And by virtue of the fact that the documents were drafted by the principals and entities that are the umbrella entities, if you will, if you look at the hierarchy and the timeline of how this all played out, the apartment complex is on constructive and actual notice that they are subject to the restrictions. I think if you look at the behavior of the appellant in this case, what you will see is that representatives from the apartment complex went ahead and attended annual meetings. They attended board meetings. They paid assessments for a certain period of time, up until July of 2019. They were intimately aware that there was a financial obligation, but more importantly, I think they're aware that as a part of this whole development, which was, again, developed by entities that were all related, that it's important to maintain the harmonious nature of this community and the financial soundness of that community by having some type of framework within which these assessments have to be charged and paid for.
Going back to the question Judge Banziger asked opposing counsel, are the notices in the chain of title for Shoreline Village Apartments?
Yes, I think that's in the chain of title because it's referenced, generally speaking, in terms of other encumbrances of record.
What are those statements?
Within the deed, I believe it states that it's subject to easements of record, other documents that are within recorded chain of title.
So the general statement of subject to easements and other restrictions, like type language in your view is sufficient to say that's included in the chain of title, so this is part of the public record regarding this particular property.
That is correct, and it is a recorded record, and it was created by Harry Giltz, who was the principal of all of these organizations, and continues to be the principal of those organizations to this day. I will note.
Does that initial document creating this entity, does it indicate that it was involved in lot number 28 or whatever lot we have here? How does it spell out? This includes these particular lots. Does it do that in some capacity?
Yes, it talks about the identification of what the different residents are going to be made up of. It talks about condominium owners, and it talks about apartment residents. So within the document itself, within the declaration, you have a specific reference to the apartment complex, which was a part of the development ultimately that was put in place by the principals in this case. And I think that if you, again, you look to that pattern, if you look to the conduct of the parties, and you look at the fact that these individuals have the ability to, in essence, remove or add encumbrances into the deeds that they themselves deed back and forth to themselves.
But you would say as far as summary judgment goes, we don't have to look at the conduct of the parties because those statements in the deed is sufficient for them in a matter of law to know this applies to this.
I think it's important to point that out, but I also think it's important to distinguish that principle from the Marketable Title Act, which is not applicable in this case. I think if we were required to look back 40 years and we met the standards of that particular act, then we might have a different conversation. But for purposes of today, as we stand here, we have a clearly written contract in place. We have a clear record of who transferred what property to whom. And at the end of the day, the apartment complex is a party to that agreement. And if you look at the conduct of those parties, again, you've got actual notice, you've got constructive notice, and this pattern of conduct that certainly indicates that the contemplation of the apartment as a part of this community was in fact important to those principles that created it in the first place.
If I understand the record, for a period of time, the Shoreline Apartment, through their association, made payments for this, and then they stopped.
Correct.
When they stopped, did they give a basis for the reason they were stopping, and that in the record?
It wasn't clear, no. They requested to go on a payment plan, and the payment plan was approved, and they didn't make payments under that plan. So, again, it is a question of having it both ways in this case. It's like flipping a coin heads or tails, and demanding as the person that's flipping the coin to be able to call both heads and tails. And I think in this instance, that's patently unfair to all the parties in this case, that the appellant in this case shouldn't be allowed to take that position based on the record in this case. The signatories on the documents, again, as I mentioned, they're all similar. Mr. Giltz has been involved this entire way, and continues to be involved to this day, as I mentioned before. And although you have various corporate entities throughout this history going back and forth, what you have at the end of the day is a community that hinges upon the success or failure of these covenants. And when you look at the declaration for the appellee in this case, what you will see is that the declaration clearly points out that there is authority to assess all of the folks that are in that community. So that includes condo owners, that includes anyone else within another umbrella organization, and includes the apartment complex. The declaration specifically lays out the notion that the apartment complex can, in fact, be assessed, and that's set forth verbatim in the declaration. So that, again, is an important point to raise here. The tenants in this case use the swimming pool. They use the hiking trails. There's a clubhouse that they use. They oftentimes, when tenants are substituted, they move, new tenants move in. There are requests from the appellant in this case to get new key cards or key fobs for access to those facilities. And that is granted. And it's granted because that was the understanding when all of this was created as to how it should operate. And again, I think it's important to note that we're looking at, a party here is looking to play both sides of the coin at the same time. Win-win. And that's certainly not a situation that I think was envisioned at the time the development was created. I'd like to go to the Marketable Title Act just briefly, and again point out that none of the principles in that case really apply here. I think if you're looking at a general reference to an encumbrance of some kind that goes back a long time, the purpose of that act is to extinguish antiquated encumbrances. That is not the case here. So the analysis as to whether or not it's a general encumbrance or a specific encumbrance, I don't think that is a test that has to be met in this case. I think you have to look at the overall circumstances here and look at the constructive notice. The document that was recorded is recorded so that it's known to the entire world. And while Revised Code 317 may not specifically mention homeowner association documents, it doesn't negate the fact that recorded documents put individuals on constructive notice that they exist. So whether it's considered a public record in terms of how it fits specifically within that statute or not, it's still a recorded document. It's an encumbrance that anyone in the world can look at and say, yes, this exists. What we're looking at, though, is a party that's potentially looking to deed their way out of that commitment. So it's one thing to say that you're not a member of the association because you didn't know about it. It's another thing to say that you're not a member of the association because now you're in debt and default in your obligation, and you no longer want to be a party to that agreement. That's what we have here. And we have arguments, I think, raised for the first time on appeal that there's no contract whatsoever that governs the conduct of the parties. And that's clearly not the case. The declaration and the bylaws and even the statute govern how this should play out. And I think it's clear that the appellant in this case is somewhat taking advantage of the fact that there may be some legal argument they can raise that they didn't know, but it doesn't negate the fact that they acted in a way that shows that they did.
So if someone would buy the property from the appellant, would that person buying the property be able to just look at their chain of title and know, or they have to search everyone's chain of title in the neighborhood?
I
mean,
think
how
that
do we get notice to future borrowers or future buyers of what their encumbrances are or their obligations are in their property?
again, I think that goes to the notion of whether the recording was a general encumbrance or not, and whether or not that is sufficient for reference in the deed. We would argue that it is. That it references that there are encumbrances of record, and the fact that a new purchaser comes in and buys it will know that they have a duty to look into that and see what is it that's recorded, what is it that they would have constructive knowledge of, and what is it that is their obligation or obligations under those particular agreements. So in this case, we believe there's a valid contract. We believe there's a valid declaration. We believe that it encumbers the apartment complex in this case. And we believe, given the overall circumstances here and looking at how this whole development has worked, that this court should find that the trial court was correct in its analysis, that it was correct in determining that there was no issue of material fact remaining to be litigated. It should, this court should also uphold the notion that constructive notice in this case and actual notice in this case were both present, because that is the case here. And I struggle at some points to understand the argument of appellant in that there is the use of all of these amenities, yet there is this blatant assertion that there is no reciprocal obligation for payment. And that's only come up recently. My understanding is that there may be issues related to refinancing or other issues that have come up that may be difficult for the appellant in this case to move forward with, but that doesn't negate their obligations here. And the association in this case has the right under the declaration not only to go after the apartment complex in this case, but to put liens on the property, to have ongoing continuing lien for those obligations, and that under the declaration it is entitled to not only an award of the underlying judgment, which is the amount that's due and owing for assessments, but in addition to that, attorney's fees and court costs. And we believe that the trial court was correct in its assessment.
1 minute of time left, counsel.
Thank you. Again, I just want to point out that this can't be a case about winning heads and tails. But I have a hard time making heads or tails in some cases here with appellant's argument, because you cannot have it both ways. And I believe that the contract is clear. I believe the parties to that contract are clear. I believe the record indicates that there was constructive and actual notice. And I believe that given all these circumstances, it would be appropriate for this court to uphold the ruling of the trial court. And with that, I yield the remainder of my time. Thank you.
Thank you.
I just had a couple comments to the appellee's arguments. First, that whole argument about the developers were the same developers for the whole development. So therefore, they just accidentally forgot to put CCRs into this one development. Well, I'd submit to this court that they put them in the other ones, and they decided, they purposely intended not to include them with this association. The person intends their natural, probable consequences of their acts, and that's what they did. They did not purposely include them here. There's no evidence in the record that would show that Gillis made a mistake, or anybody made a mistake. Number one.
So their argument is, and I understand it, basically that, well, if we don't say you have to pay, you get to use it for free. Your position is your clients get to use Shoreline Village, get to use it for free, and that's what the intent was here. They get to use that club and pay anything.
No, I think their intent was this was a club, like any athletic club. They're paying a fee to use it, and they should be able to pay a fee to use it, and they did. When they realized that it was more than just for use of that club, there was all these other restrictions that are contained in the CCRs, that's when they drew a line. And so that is what happened here, that the whole, and there may be unjust enrichment, there may be some, transfers of money, and although it's not in the record, it's not part of this, but there's been proposals made to make sure it's all rectified. I mean, no one's trying to hold money from anybody in this case. He said, he talked about the general reference, and in the appellant's position and in the trial court's position, that's enough to bring in CCRs. And I remind this court that the trial court, in their opinion, says they're confused by this whole case. And so we looked at the case law, we looked at the statutory law in this appeal, and this Ohio Supreme Court, Erickson versus Morrison, it's a 2021 case, cited in our briefs. They talked about vague language in a deed, which is vague boilerplate language accepting any number of reservations which may or may not exist. And they, relying on Ohio Revised Code 5301.49A, said a general reference in a deed is not sufficient to preserve an interest from being excluded or extinguished or involved. A general reference cannot bring in CCRs or put a restriction on somebody else's property. It's not enough, because that would require a title company to search, as you had indicated, Your Honor, that they would have to search everybody's property to get a title report. Again, the fact, Mr. Cottle was correct, there is a clear record of transfers. It's all very clear. The only thing that's confusing about it is the names, but they're still separate entities, they're still separate transactions, and they're still separate restrictions, still separate, all those transactions are different. And there's different declaration for the athletic club, different declaration for the apartments, and for the condos. And those are the developments that have been built so far. And so that's how this was planned and developed. We know that's what they intended because that's what they did. And there's, again, no evidence in the record to suggest otherwise. As I indicated, that Minnewanka case that's been cited is lot ownership. I mean, you can't just make the survive because somebody knew about them. Knew that they existed for another association, knew they existed for another condominium association. It doesn't make them binding on Shoreline Village Apartments. They're not, they have to be in a chain of title, they have to be an official record, and we know that they aren't either one of those. The whole business about, well, you know, they know about it, and it'd be the right thing to do, and all that doesn't fit in this real property transactions. Otherwise, you'd never have a clear title.
I'll move your time is up for
Okay, thank you. I figured we were very full, and appreciate your time today. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of courts, also be available on the Ohio Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your